Thank you all, and I have to say, you all are heroes. And the guys who participated in the hunger strike were heroes. Without all of us working together, this day never would have come. We're here today to celebrate the great victory that was won in this settlement, which was won by the perseverance and determination of the men in the shoe, of all of you here, the family members who provided the bedrock support and the hope for those guys in the shoe, and without which this settlement would never have been possible. As the statement of the plaintiffs, which they composed in a meeting together on the phone that we had to ratify the settlement, which we, the lawyers, were the note takers. In their statement, they said this is a monumental victory for all prisoners, but it is just one step in a long struggle to fundamentally change the prison system in this country and the criminal justice or injustice system that we have in this country. So we celebrate this with great joy, but we must at the same time remember the difficult struggles that lie ahead. This is just the first step. And it's a great step, but we have a lot of work to do. And so today I want to both celebrate this great step, but talk about the work we have to do. I wanted to start just by saying it's been a great honor and privilege to represent these men and to get to know many of you here and many of the family members and supporters both in LA, in San Diego, in the Bay Area. I've had a long legal career, maybe too long, and I've represented many illustrious people, congressmen, senators, celebrities, national organizations, prominent academics, and of all the people I've represented, the proudest I am is of these men in the shoe. And I told them that at our last meeting after we decided to ratify this settlement. And I'm proudest of them because of the great perseverance, the courage, the humor, the unity, the collective strength that they have represented for all these years. It is remarkable, and as I say, I am very proud to represent them. Today I have three things I want to talk about. The first is the settlement, which you all know about, but I will try to give a summary, fairly briefly. But academics, professors are not known for their brevity. Second, I'd like to talk a little bit about how we got to this settlement, how it came to pass. And third, I'd like to talk about the path ahead, the tasks we still have to accomplish, and the role that you folks can play in that path. First, the settlement, I think the plaintiffs felt was a great victory, which is why we took it. And we struggled for 4 months, very arduously, to get this settlement. It does a number of things. The first is that the people in the shoe are going to get out, and soon. Within 1 year under this settlement, everybody in the shoe statewide, not just at Pelican Bay, the case at Ashker versus Brown was initially just about Pelican Bay. Everybody statewide in the shoe will be in general population unless they have, in the last 2 years, committed a shoe offense. Even those who have committed a shoe offense, if they have spent more than 10 years in a shoe, will be placed in a alternative general population unit, but it is considered by, I know Secretary Beard, as a general population unit, a very restrictive one, but a general population unit, which I will get into later, if they have spent 10 years in the shoe, even if they have a shoeable offense. That's the first thing. So you will, at some point soon, be able to hug your loved ones, which you have not been able to do for all these years. Which, to me, is one of the greatest injustices of this whole system, of how you could deprive somebody of touch, which is a basic human need. Second, going forward, CDCR will no longer place people in the shoe for alleged gang affiliation. So no more will the tattoos, will the photographs, will the artwork, will the political literature, will your name on a list as an alleged gang member be used to put people in the shoe. The only way they'll put people in the shoe is if they've committed one of a list of shoe offenses. And we had to struggle for many weeks to try to narrow those shoe offenses. And it's still not to my liking, and I'll get to that. But we were able to narrow it. For example, the initial list that CDCR gave us said, if you're a gang leader, you could be put in the shoe on a shoeable offense, that would be a shoeable offense. We said that's monkey business. You're just going to call all these people gang leaders and you'll put them back into the shoe. And our guys came up with an alternative, which was first, get rid of it, and second, if you can't get rid of it, which I was not able to do, to then say you have to be a gang leader and commit one of the other shoe offenses, which nullifies that provision because you basically have to commit assault, murder, or one of the other shoe offenses. Being a gang leader will no longer be a reason to place people in the shoe. Not just a member, not just associate, but even if they say you're a leader, that's not enough. They have to find you guilty after a due process hearing, which, as we know, is not to our liking often, but at least it's better than what used to exist, of a shoe offense. So that's going forward. Third, there will no longer be indeterminate shoe offenses. If you commit one of these shoe offenses, you will get a set term. And unfortunately, if the shoe offense has been proved to have a gang nexus, you will then have, after your shoe term ends, a 2-year step-down program, which none of my clients liked. I don't like, but that was part of the compromise. But it'll be determinate. If at the end of your shoe sentence and at the end of the step-down program, you have not committed another shoe offense, you will be out. You will be out. There's none of this going to be inactive reviews. Every 6 years they review you and they decide whether they keep you in, and they keep most of the people in. If you don't commit another shoe offense, you are going to be out. So you're getting a determinate sentence. We've done away pretty much with indeterminate sentences. There is one exception, and and when I explain it, you'll see how difficult some of these negotiations were. CDCR said, we still have a category, and this is the fourth thing in this settlement, of administrative shoe. Well, who goes in administrative shoe? Very dangerous people. Well, we said very dangerous people. That was the original proposal. Very dangerous. I'm obviously paraphrasing it, but it was people who are a danger to the safety of the institution or to them or to others. We said that exception is so broad that you could just start putting hundreds of people back in the shoe. We can't go for that. And my client said, we're not going to stand for that. And I said, we're not going to stand for that. CDCR said, but there are some people who we think are pathological killers, and if we let them out, they're going to kill again. We said, well, we think you should shut the shoe down. They're not going to do that. We knew that. Not in this settlement. That's our goal. That's our goal. And this is the first step towards that goal. But what we were able to do in this was to say, well, okay, you got to narrow the criteria, number one. So it can't be very dangerous people. You have to have compelling evidence that they are going to do something very dangerous. Well, that's very different than just CDCR saying they're dangerous. Compelling evidence, number one. Number two, there's got to be review before a judge. Not review simply by a CDCR official, but review by Magistrate Vadas, who agreed to review any case of somebody being put in administrative shoe who we bring to. So now we have both due process, we have strict criteria, some due process, and a court review. Third, we said even for those people, we're not going to let them be put in the shoe the way you've had the shoe being run up till now. You've got to give them a lot more time out of the cell. And their proposal was up to 20 hours a week. Can anybody tell me immediately what's wrong with that proposal? Up to 20 hours a week. That could be 1 hour a week. I said, you can't do that. You've got to give them at least 20 hours a week. And the settlement says 20 hours a week minimum. So that at least is a lot more out of cell time. And then also they've got to be reviewed, not every 6 years, but every 180 days. They've got to be reviewed by the DRB. And the presumption is that they're going to eventually get to the main line also. Even these people in administrative shoe. And still we were not happy. Beard told me, this is only going to be for a few people, the pathological people. I said, all right, he put that in the agreement. Right. That's only going to be for, oh, no, we can't put that in the agreement, you know. No. So we finally agreed that it is, to put in the agreement, that it is CDCR's expectation that this will only apply to a small group of people. That's in the agreement. So if they start putting in hundreds of people, we know they're violating the agreement under this. So that was another thing we won. Another part of the settlement was, and this came from the plaintiffs. I'll explain this how it came later. But it came from the plaintiffs themselves, this proposal. My view in this, and I pushed for this very hard, and CDCR did not want to do it, but they finally did, was that somebody who spends a prolonged period of time in the shoe, and you still think is very dangerous. Let's say they have some good evidence that they're very dangerous. They've just committed an assault 6 months ago. In my view, it's still torture. Even if the guy has committed an assault, even if the guy has committed murder, you wouldn't say, well, okay, you committed an assault with your right hand, so we're going to cut off your right hand. You can't do that. This is torture, what they've been doing. They, of course, won't call it that. They won't call it even solitary confinement. It reminds me of the CIA, the way the CIA comes up with all kinds of names for what they're doing. You know, in the 1980s, they said, we're neutralizing people. Well, that meant they were assassinating people. It's not solitary confinement, it's restrictive housing. But in any event, we said, okay, there's some people maybe you have to separate from the general population, but you don't have to treat them in a draconian, punitive, torturous way. So set up a unit that separates people from this few people who you're saying are dangerous from the general population, but gives them contact visits, phone calls, small group recreation, small group programming, small group religious services. They don't have to be in a yard with 200 people where it's hard to supervise, but 4 people. Give them contact. don't isolate these people totally. And CDCR in this agreement agreed to set up this type of unit as an experiment, as a model. And they will put everybody who's been in the SHU statewide for more than 10 years who have committed a SHU offense and therefore can't go to the general population. They'll place in this unit. And we'll see how it works. If it works, I think it could be a model for the rest of the country eventually to get rid of the SHU. Totally. That our alternative, and one time I spoke here, I said we have to come up with an alternative. This was the alternative. The alternative is restrictions, separation from the general population, but not torture, not isolation. There is no need to totally isolate people. Again, it's going to be a struggle to see how this unit turns out. You know, it could turn out simply as SHU light. That would be bad. But they agreed to the name restrictive custody general population. Beard told me and assured me this is going to be a general population unit. The guys are not going to be walking around in restraints in general. I mean, if they act up, then they'll be put in restraints, but not in general. It's not going to be the SHU. We'll see. We have to hold their feet to the fire on that. Another thing in this agreement is that we get 2 years of court monitoring, supervised by a magistrate judge, Vadis, up in Eureka, who's pretty familiar with this situation, and any violation of this agreement, we could take to him. And so it's not just us. As I'm going to talk about later on, we're going to have to do the basic monitoring. But we at least have some judicial power that we could go to if CDCR does not comply. And if they are found to be in violation of the Constitution 2 years from now, then this agreement is going to be extended. Then the court monitoring will be extended until they cure the constitutional violations. And finally, and in my view, probably one of the most important things we did in this agreement, which has not been really publicized, is not part of the, I haven't seen very many newspaper articles talk about it, but it's fundamental to the Center for Constitutional Rights philosophy of litigation, fundamental to my litigation, and my philosophy, and it's been a key part of this whole struggle, is that this struggle is not about lawyers changing the world. This is about empowering people to take control of their own destiny and to be able to make decisions or participate in decisions that affect their lives. And just because the people here are prisoners does not mean that they should be disempowered, does not mean that they should be denied human dignity, and does not mean that they should be treated on a level that's not like other humans. That was our basic philosophy. To do that as a litigator means that you have to have a different kind of relationship with your client. You can't see yourself as up here and your client down here. You can't see that you are the knowing be-all and end-all, that you're the hero and your clients are simply there for the ride, or that you are the person doing it for them. We're all doing it together. It's a democratic, egalitarian view of litigation. So that required a number of attitudes throughout the litigation and also some key points in the settlement which almost derailed the whole settlement. And you may be very surprised about what these points are. First, it meant that we had to listen to our clients. This is not a one-way street of us. We have some legal skills. I probably know a lot more about the law than most of the clients. But they have a lot of practical skills. They know about the SHU. They know about the system. And it has to be an open dialogue. Not only that, but I can tell you there are a number of top-notch lawyers in the SHU. who have unfortunately never earned the law degree. And a number of them I'd like to send to law school, including somebody who I really want to do something for. He wants to get a paralegal degree from the SHU, and some outfit's going to charge him a lot of money, and unfortunately I don't have the money for it, but I'd like to figure out a way to raise the money from him. That's Eduardo Dombrichi. Eduardo Dombrichi, when we brought this case, looked at the complaint and said, he said, you left something out. We should be given full due process hearings like the disciplinary hearings. He wrote me a long memorandum to that. I said, you know, I litigated in the Supreme Court this issue. This won't fly. I sort of put it aside. I read it, but I put it aside. That night I didn't sleep that well. And I woke up and I said, you know, I wonder if this fellow Dombrichi is up onto something that we lawyers have just not considered enough. So I asked my research assistant, I get a research assistant, I asked my research assistant, read this and analyze this. And we talked about it, thought about it, I raised it with the other lawyers, and I said, Dombrichi is right. Dombrichi is right, and we should make this a main point in our case. And in our summary judgment motion, and in all that we did, we focused on Dombrichi point. And you know, Dombrichi won. In this agreement, CDCR has agreed that before putting anybody in the SHU, for whatever reason, they've got to give them a full disciplinary hearing. Dombrichi was vindicated. And we had not thought of it enough. And this is just one example of many where my clients taught me something that I didn't know. And the key to being a good lawyer is understanding that, is recognizing that, not dismissing. That's the first thing. Second thing is, when we started the whole settlement process, CDCR expected us to do what generally is done, which is we'd come up with a proposal, a settlement offer, settlement proposal, and we'd take it to our clients individually. There were 10 plaintiffs, and we'd discuss it with them, see if they liked it, and then present it to CDCR. That's a lawyer-driven model. We said, no, that's not what we're going to do. We have to meet with our clients, and they have to come up with a proposal together with us. They said, that's not possible. We don't have meetings of prisoners here in CDC at Pelican Bay. That's not the way it works here at Pelican Bay. You don't understand how it works here. You can meet with an individual plaintiff, and then you can meet with another plaintiff. We'll allow you to meet with them, but individually. We said, that's not how human beings interact. They don't interact with the lawyer going and meeting individually. If this was not prison, we'd all meet together and come up with a proposal. They said no. We went to Judge Vadas, who was supervising this process. And we said, we can't settle if we can't meet with our clients. And we only can meet with them if they're allowed to talk to each other, not if they just talk to us. And under pressure from Judge Vadas, CDCR agreed to allow us to have a meeting. First one meeting, and then morphed into a second meeting. And just to give you a description of these meetings, I don't know if you've seen Silence of the Lambs, or if you know, there are these booths that they have. They look like the old telephone booths before there were cell phones. And they are totally enclosed, but you could see the person and hear the person. They lined up 10 of these booths side by side, put each of our clients in there, side by side, and then put me and Ann Wiles on a table in front, and they made us wear these ridiculous Green Beret outfits with, like flak jackets, and so that if one of these clients who had somehow gone through the searches and had a knife or a gun and could somehow get out of this enclosed telephone booth, we'd be protected. And we said, this is ridiculous. They said, you can't do it. We agreed to do it. It was symbolic of the exaggerated, ridiculous fears that CDCR has of these men. But in any event, in this meeting, these two meetings, which took 3 hours each, we hammered out an agreement, and our guys remembered that there had been a Max B program 25, 30 years ago, which represented an alternative to the SHU, where people could be put in a segregated unit, but not isolation. And they came up with this plan, which eventually came in through this settlement. So that was driven by our clients. Well, I never would have thought of it myself. In the settlement process, we demanded that we get meetings that we couldn't just ratify an agreement. We had to discuss it with our clients, see what they thought, get feedback, see what they wanted to do. And we had a series of 4 meetings. Since all the guys now are at different places, 4 of them at the Hatcherby, a couple of them here, a couple of them there, a couple of them still at Pelican Bay, we organized a conference call, 4 of them, with all the guys to discuss all these proposals, give us feedback, and instruct me as to how to negotiate. This was all part of this process of focusing on the issue of human dignity. That the taking away of human dignity includes not just keeping people in the SHU, but not allow that the whole process of it would be SHU-like, and we refuse to participate in that. In the final settlement, there are a number of provisions which reflect this, and which CDCR strongly objected to. The first is they're going to have programming. You know that they have this programming for the step-down program, which my clients consider Mickey Mouse and idiotic. So one of their demands was that they should change the program. Secretary Beard, CDCR, said, we're not going to do what you tell us, but we'll review it. We'll hire some experts to review it. We said, okay, that's good, hire some experts, but you got to, the experts and you have to discuss it with our guys, with the representative of the plaintiffs, because they know what good programming is and what idiotic programming is. And you've got to discuss it with them. They said, no, we don't discuss it with them. We have experts, we have lawyers. In the final agreement, 4 representatives of the plaintiffs, whoever they choose, will discuss with CDCR the nature of the programming, discuss it with the experts, and they'll have some input. They won't have the final decision. CDCR is not going to allow them to do that. But they'll have input. They'll be treated as human beings, as somebody who should be listened to, should be respected, and should be heard. We also demanded that not just the lawyers, but our clients, the representatives of our plaintiffs, get to meet with CDCR to discuss the enforcement of the agreement. Because a traditional agreement, there's a monitor or a master or the lawyers who enforce it. That is not the case here. That I can tell you. We're going to be enforcing it. Judge Vadas is going to be enforcing it. The key to enforcement is in this room and in our plaintiffs, in the SHUs. Without your input, this will not work. And so we said you have to be able to meet with the plaintiffs. We have to be able to continue these plaintiff meetings. And Jeff Beard said to me, it's never been done, would be unprecedented. We're not going to do that. And I said, yeah, that's exactly why we want to do it, because it's unprecedented. That's exactly why we want to do it. And they refused. They refused. The settlement was held up because of that. Because to me, if you are unwilling to listen to people, to sit down and talk with them, it means that you're not treating them as humans. And the core of this whole case is not simply what the criteria is for the SHU, but treating people with respect, treating people with dignity, treating them as humans. When I treat somebody as a human, I'm willing to talk to them. I'm willing to listen to them. They're not a monster. And we had to win on that. So they said, we're not going to do it. We said, okay, let's take it to Judge Vadas. And they agreed. And Judge Vadas made us have less meetings than we would have wanted, but we won on the principle. We won on the principle. And that, to me, is a very important aspect of it, because it's the key to the way the CCR, the Center for Constitutional Rights, litigates these cases. I think we have three key principles, and this is one of them. The first is that we represent movements. We are there to help and aid movements. We took this case in a large part because the guys themselves were in motion. They were in hunger strike. They came out and reached for our help, and that meant we had to help them. Second, we take cases where we think there's injustice, oppression, even if the courts are not generally responsive to those cases. And as I'll explain later, the courts haven't been responsive in these kind of cases. But we said we've got to take it anyway. And the third is we litigate to empower the people themselves and not just to empower the lawyers or to win particular substantive reforms. This is about changing our society, not just winning a particular reform. And the key to changing our society is to get people to treat people differently. And the shoe is the most outrageous example of it. So that's the settlement. How we got there? I'll move quicker. Clearly, the first and the key thing to this settlement was the hunger strikes, the 3 hunger strikes, and secondly, and cannot be ignored, is the support that the men got from their families, from their supporters outside. You know, people think, well, we didn't, there wasn't anything dramatic. It wasn't like there was a demonstration of 100,000 people. One of the most famous Americans, Susan B. Anthony, once said that her causes, which eventually resulted in women getting the right to vote, was like a drumbeat of agitation. A slowly beating drum. And that's what you folks did. You kept the issue in the public mind. You didn't let go of it. You didn't give up. And that, I think, led us to today. The other aspects of why, when we first met with our plaintiffs and presented a settlement proposal to CDCR, I was going to use a kind of off-color way of presenting what they did with the paper, but I won't say it. Let me just say they didn't respond to us. They didn't respond to us. They didn't respond to Judge Vadas. They said, we're not going to settle. We have no response. That was about 2 years ago. So what changed? What changed was when they started their own reform plan, which was a half-baked, measly reform plan, and they started moving people out, we followed them. And because of our clients again, Jeffrey Franklin, Satawa and Tehachapi, once they moved those guys to Tehachapi, Danny Troxel, and George Ruiz, they said, you've got to expand this case to take into account all the shoes wherever people are being moved, as long as they're in a shoe. And really, did I want to do that? I had enough work on my plate just with Pelican Bay. But we thought about it, struggled with them, tried to figure it out, and realized they were right. And we filed a supplemental complaint, which could have delayed the case, could have undermined the whole thing. And it said, wherever you are in a shoe, if you've been first to Pelican Bay and they move you somewhere else, the case is going to follow you. And the California's attorney argued vigorously against this, but in the spring, Judge Wilkin agreed with us and agreed to expand the case. At that point, I think CDCR realized that the reform was not going to moot the case, that they had to come to terms with us. They couldn't just move people out and hope the case was going to go away to another shoe. Second, we filed our expert reports, 10 expert reports, 500 pages. They They were from psychologists, famous sociologists, neuroscientists, a guy at Berkeley who's an expert on the science of touch, and prison officials from Mississippi, not known as normally the great progressive state like California, but Mississippi, who said what California is doing is ridiculous from a penological perspective, not just from a human rights perspective, from one of the most prominent prison experts worldwide who used to run the prisons in England and got rid of their shoes there, said that it can be done, from the top prison official in Ohio. And we also filed a expert report from the UN Rapporteur on Torture, who said he's traveled all around the world visiting prisons in his capacity with the UN, all around the world, and nowhere has he seen this many people held in solitary confinement for so long with such little justification. He didn't just say this is what international law says. He said this is his experience. And I think that also put a little scare into CDCR, that maybe we could win this case, and that they could lose a trial. And also, I think the fact that they had transferred a lot of guys into the general population, and in part because of the agreement to end hostilities, because of the unity of the men, these guys weren't getting into trouble. And the facts on the ground, not just what the lawyers were doing, but the facts on the ground showed CDCR that they could do this and it might work. And so they came to the table. They approached us. They said we're now willing to discuss it, and that's what led eventually to this settlement. Now, does the settlement have flaws? Yeah, it has serious flaws. Keeps the shoe for a long period of time. I mean, to keep somebody 4, 5, 7 years in the shoe, that to me would to me be a constitutional violation. But because of the case law, because of the restrictions of the legal practice, we couldn't get rid of the shoe totally. We wouldn't have even gotten rid of the shoe if we had won a smashing victory in the court. Does it keep this step-down program? Yeah, and that I think is unfortunate. But we couldn't get rid of that. There are a number of problems or potential issues in this settlement. But overall, I think it's a remarkable victory from where we have been to where we are now. It's a sea change. So, what's to be done? And what's the role for you folks? I think there are 4 key areas that we have to work on. First is we now have a settlement on paper. We have to enforce it. For example, they're supposed to go through everybody in a year and put them into the main line if they haven't had a shoe offense. Jeff Beard assured me that they were going to start on this even before the settlement was officially approved. And they are, but weekly. We've got to make sure that every provision in that settlement is enforced. And that's going to take you folks telling us what's going on. Us lawyers, I can't be, first of all, I certainly can't because I'm stationed in Pittsburgh. But even the California lawyers can't be everywhere. But the prisoners, as well as their family members, can report to us on what's happening. You are the eyes and ears of whether this settlement is really being enforced or not. And then our job is to take what you've given us and investigate it and bring it to Magistrate Vadas. And we're obviously going to try to find out the information ourselves, but I think this has to be a joint enterprise. Second, that's the basic enforcement of the agreement. And there are a lot of provisions, and we have to make sure they're all enforced. As the guy said to me in the meeting, we're going to accept this, but we want 100% enforcement. That might be hard to do, but we should aim for that. Second, there's going to be a lot of guys in the SHU now in general population. And this has got to involve a culture change in CDCR. And there are going to be people who are against that culture change. And there are many ways, if a guard or somebody wants to screw things up, and hopefully most of them will not, but hopefully mostly are not, and I'll tell you what's in the agreement, which should help. But if they want to create evidence on somebody, if they want to retaliate, and that's already, we know, been happening a little bit, or we believe it's been happening. And we don't want a situation where 2,000 guys get out of SHU into general population, and in 2 or 3 years from now, 1,000 are back on, various charges that may or may not be true. How to prevent that? Again, a lot is going to fall on you. And we've also got to, we have to be vigilant. I would like, if we could, to be able to hire investigators. The court will pay us attorney's fees, but they're not going to pay us for investigators or experts. To investigate, at least take a handful of these cases and say, if this is pretextual, let's prove it. And we always can go to Judge Vadas. We don't have to just file a 602. I mean, the guy has to still file a 602, but then we have a forum to bring this to. That's going to require a great effort to make sure that once this settlement is implemented, we don't just go back to the same thing under another form. Third, I think we should take what we've done in California here and try to use it as a model for other states around the country. Arizona, Texas, they still put people into their SHUs for gang membership. There are other states that have indeterminate SHUs. There are very few states that have this separate but not isolation kind of unit. And I think you folks and we need to publicize this and to say, we did this in California, you should do it elsewhere. And it's going to, in part, depend on you. And finally, the SHU is the tip of the iceberg in terms of the problem here. The problem is with the whole California prison system. When you get to general population, there is not a welcome wagon there with programs that are meaningful, vocational opportunities. We had a psychologist, a well-known psychologist, go up and interview 50 randomly selected people in the Pelican Bay general population in the main line and 50 SHU prisoners. And one of the key expert reports was that he found a significant psychological difference between that. But he was shocked when he got to the general population to what the conditions were there. The people in the SHU get 1 hour a day, 1.5 hours a day out of cell. Many of the people in general population get 2 hours a day out of cell. It's in a group yard, not in isolation, but it's only 2 hours a day out of cell. That's not my conception of general population. For many of them, there was no vocational opportunities. There was minimal educational opportunities. So we've got to work to change the main line, because now 2,000 of our folks are going to be in the main line. And we have to instill a different attitude in the main line, that prisons should be rehabilitative. They should have vocational training for people. They should have educational training for people. The idea is not to just warehouse somebody, but to give them the tools, or give her the tools, to make it when they get released. And that's a major task which this agreement only begins to touch. Begins to touch it because it requires training of staff. And in my view, the training of the staff is how to treat people differently. That's part of the training. It's not just this provision says X, Y, and Z. It's how to treat people differently. This summer, I had the opportunity of going to a maximum security prison in Norway, where the prison houses murderers. It had a segregation wing. It was remarkable. I won't get into it now. I'm perfectly happy to answer any questions on it. But we were taken, my wife and I were taken on a tour by the deputy warden for about 5 hours. And what he kept on repeating was our basic philosophy in this prison and in Norway is that you can treat people as criminals, or you could treat people as if they have committed a criminal act. Not as criminals, but simply have at some point in their life committed a bad act. And we choose the former. We choose the latter in Norway. Here in the United States, we choose the former, and that's a fundamental change that we have to develop in this whole system. So those, I think, are our tasks. I just want to end by just going back again and looking at the meaning of this settlement. I think you could see it as on 3 levels. The first level is CDCR has agreed to meaningful, substantive reforms, which, if we enforce it, will really change the system. And I think it's not just us enforcing it, but I also think it's the guys in their agreement to end hostilities, which was fundamental to this whole thing, which will change the situation. That's one way of looking at it, on one level. A second way of looking at it is that we started the struggle, the guys started the struggle 4 years ago in the face of incredible odds. They went on hunger strike. CDCR had instituted this policy for 25 years. There was virtually no change despite court cases, hunger strikes, political agitation. And what were these guys thinking that they could change this situation with their hunger strike? You families supported them. And I know Dolores and Irene and others have done hundreds of hours of work in a struggle that 4 years ago looked almost hopeless. And the second meaning of this is that even in the face of great odds, we can win. Even in the face of great odds, we can change if we have the courage and determination and persistence to do it. You know, the Center for Constitutional Rights also represents the Guantanamo detainees, and I worked on that case. And that was also hopeless. Nobody gave us a chance. No lawyers even wanted to take it. And by the way, this case, it was also difficult to get California firms. We had California lawyers working on it, some of the great political lawyers in California, but big firms, which we would need, it was not easy to find. Because one reason was because it was a tough case. In fact, Terry Cooper's our psychologist, our expert, who's a well-known psychologist, called me a couple weeks ago and said, Jules, when you started this case, we all thought it was a pipe dream. We thought it was a sure loser, and look where we are now. The same thing with our Guantanamo cases. And yet, we won in the courts 3 times. After we won the first victory in the Supreme Court, the New York Times ran an article on the Center for Constitutional Rights. And the article was something like a little band of scraggly lawyers with beards and had brought the government to its knees in a victory which nobody thought was possible. And it made me think of the children's story, The Little Engine That Could, which I got an award at Pittsburgh, and my wife presented me with the present, The Little Engine That Could. It's a great children's story, but it's about this little train that chugs up the hill and It's not going to get over the hill because it's got a small, but it just keeps on chugging and eventually gets to the other side. And that's what you folks did. That's what we all did here. And that's the second meaning of it. But you know, to tell you the truth, that to me is not the most fundamental meaning of it. The most fundamental meaning of it doesn't have to do with the fact that we were victorious. American life and American sports and American culture plays a huge emphasis on victory. And we had a victory here, like we had in the Guantanamo case. I can't tell you how many cases I've lost. Because when you're fighting for justice, when you're fighting against oppression, you often lose in the courts. The only way to avoid the losses is only to take the cases that are sure winners. And those cases often don't involve the most fundamental aspects of injustice. So if you are doing this kind of work, you've got to be prepared to lose. And I've thought about this long and hard, and I decided that the key to success is not winning or losing. The key meaning to this settlement, I think, well, they're all three. There's substantive reform, the fact that we could win, but a third is that we were engaged in this struggle and did something for principle, for living out our values, and something that had a lot of meaning to us. This struggle, I think, win or lose, gave these guys meaning, gave them hope. It gave all of our lives a meaning. Whatever is in that settlement. The fact that we struggled, the fact that they didn't take this oppression, this torture, without resistance, the fact that you were not willing to be silent, and the fact that I and the CCR and the other lawyers were willing to support them. All that, to me, and I think to you, gives meaning to our lives. And it's that meaning which is the critical aspect of this whole struggle. And I think we have to continue to struggle as part of continuing to lead a meaningful, productive life. Thank you.